Start the
Waalaikumsalam.
lecture today on Equitable Estoppel. So I hope that everyone is doing well. So today we're going to spend about 1 hour on this topic and later to discuss on Estoppel and Equitable assignment in Q&A sessions. So it is a lecture and math tutorial altogether. This lecture will be recorded in 2 sections, or 2 parts, so that will be much easier for you to listen. So today we're going to discuss on equitable estoppel. Basically, there are many types or many categories of estoppel. So this is basically what we call as reliance-based estoppel. As you know that in equity, the transaction is not registered, but based on the conduct of the parties, the plaintiff is estopped from relying on estoppel. Sorry, the plaintiff is estopped from going back to the old promise that he has made before. So we're going to discuss on the meaning or the definition of estoppel and what are the requirements to establish a case for estoppel. So there are a few types of estoppel here: estoppel by representation, proprietary estoppel, and promissory estoppel. So let's go first with the definition of estoppel or the characteristics or elements of estoppel. This is the elements of estoppel is discussed in an old case in the United States. So estoppel basically exists in almost all legal systems in domestic and international law. The main point that we'd like to discuss today is not so much on the authority, even though it originally came from the US, but the principle here is for us to look into. So according to the case of Dickerson and Colgrove, the vital principle is that he who by his language or conduct lead another to do what he would do, what he would not otherwise have done, shall not subject such person to loss or injury by disappointing the expectation which he acted. Such a change of position is sternly forbidden. It involves fraud and falsehood, and the law abhors both. The remedy is always so applied as to promote the end of justice. Basically, if you look at the cases or the requirements of estoppel, you will realize that basically there are 2 main characteristics. Number 1 is there is reliance. So the relationship is between promisor and promisee. Okay, promisor basically is the landlord or trustor or the person who owns the property. Promisee is the person who rely on the promise. Okay, so the promisee basically rely on the promise, and later the promise is denied by the promisor. So in estoppel, the promisee will act based on the promise given by the promisor. When we say there is a reliance there by the promisee, we look at the conducts of the parties. So conducts like, for instance, the promisee has spent money on the land. This promisee has spent money, for instance. There is a case where you see later, based on the promise, based on the reliance of the promise given by the promisor, the promisee has spent money on the land, has built houses on the land, has cultivated something on the land based on the reliance. So there must be sort of like spending. It can be in terms of money or in kind, as long as you can show that there is reliance. Number 1. Number 2, if you look at this this judgment, the second element is on detriment. Detriment where because of the denial of the promise by the promisor, the promisee has suffered losses. Okay, so the elements of reliance and detriment are very important in estoppel. After all, if we look at the transaction in between the parties, if you invoke an estoppel, the promisor is estopped from going back to his old promise, meaning that he is estopped from denying the promise that he had or he has made before to the promisee. So based on the unconscionability doctrine, the court allow the promisee to invoke or to be successful in the claim of estoppel. In this case, Dawson's Bank and Nippon Menkwa Kabushi Kaisha. Just now we discussed about the two main characteristics of estoppel. There are also other elements, of course, but that is the key characteristics. The other thing that we have to understand is, or the other issue that we have to understand is whether estoppel can be a cause of action. Based on this case, estoppel cannot be a cause of action, but more to strengthen the cause of action by the plaintiff. For instance, there is a breach of contract. There is a contract entered between the promisor and promisee where the promisee can enjoy the land as long as he pay the rent, for instance. So he can plant anything on the land, he can cultivate anything on the land, he can build houses, for instance, okay, based on that promise. So that can be considered as a contract. So estoppel, the function of estoppel is to support the cause of action. Based on this case, estoppel cannot be a cause of action. It's more, the function of estoppel is to assert the existence of some facts which would destroy the cause of action. So it's more like, the function of estoppel is more like to support the cause of action. However, it is a different position in Malaysia, where in the case of Bosted Trading and Arab Malaysian Merchant Bank, Justice Gopal Sriram said the parties can invoke estoppel as a cause of action if you are the plaintiff, and also estoppel as a counterclaim. So in other words, both parties, plaintiff and defendant, can invoke on estoppel. The maxim estoppel may be used as a shield but not sword does not limit the doctrine of estoppel to defendant alone. Plaintiff too may have recourse to it. Estoppel may assist the plaintiff in enforcing a cause of action by preventing a defendant from denying the existence of some fact which would destroy the cause of action. So the doctrine of estoppel is available for both the plaintiff and defendant as a cause of action, as a claim, and also as a counterclaim. Right, next we're going to look into the type of estoppel. Estoppel by representation. The general guideline we have in the Evidence Act 1950, Section 115, where it deals with estoppel by representation or estoppel by conduct. In this section, it provides that when a person has by his declaration, act or omission intentionally caused or permitted another person to believe a thing to be true and to act upon such belief, then neither he or his representative shall be allowed to deny the truth of that thing in any suit or proceeding between himself and such person or his representative. So this estoppel is based on the representation or conduct of the promisor. if you look at this section, there are two elements, the main two elements there, where you see the reliance and detriment, where the promisee rely or believe a thing to be true where he act upon it is considered as reliance. And because of the conduct, it must be proven that the promisee has suffered losses. But this is purely based on the conduct. Okay, as an example, this is an illustration under the section. When A intentionally or forcefully lead B to believe that certain land belongs to A and thereby induces B to buy and pay for it, the land afterwards becomes the property of A, and A seeks to set aside the sale on the ground that at the time of the sale he had no title. A may not be allowed to prove his want of title. So here, in common law, you can say there is a estoppel by pies or by convention under common law. So almost similar to what we have in equity, where this is considered as misrepresentation. But the misrepresentation or false representation by A here does not make the transaction void. B can invoke estoppel on the ground that he has acted on the representation made by A that the land belongs to him. So B has bought the land when A later said that he denied the right or the title over the land. A has stopped from doing that, so B can invoke an estoppel to defend his right. So there are three elements for estoppel by conduct. Number one, there must be a clear representation. Number two, representation must be of an existing fact. Number three, there must be reliance on the representation. In the case of Associated Pen Malaysia, Siemens Sdn Berhad and Syarikat Teknikal Kejuruteraan Sdn Berhad, the Supreme Court held that estoppel in any form, especially by conduct or by misrepresentation, ought to be specifically pleaded as it was a material fact which would take the opposite party by surprise and raise issues of fact. All right. If we are going back to the example or illustration just now, the material fact is on the sale, SPA, sale and purchase of the land, right? So B relies on A's promise. A has misrepresented B. So in this event, this is considered estoppel by conduct. But if you, as the plaintiff, invoke estoppel by conduct here, you must plead on the specific facts of the case. So the specific facts of the case here is on the title of the land, because A claimed that he had the title over the land. Now that is the material facts there. So that is the existing and material fact in that illustration. I see one hand up. We will open for Q&A later. Yeah. Let's go with the first element, that there must be a clear representation. In the case of Robertson and Minister of Pension, in this case, an officer claimed the pension. He relied on a statement given by the War Office that disability has been accepted due to military service. So he did not seek independent medical opinion. The Minister of Pension ruled out that the officer's infirmity was due to war service. This was affirmed by the pension appeal. Therefore, the ministry was stopped from denying the application or the applicant qualified for the pension in future. Right here, what was the statement or what was the representation made by the ministry or the minister is that disability has been accepted to allow the officer for the pension. So meaning that it is already listed in the in the disability category. So you do not need to get the medical report to support your application for pension. However, that was later reversed in the court decision. The minister later reversed that. The Minister of Pension later found that the officer's infirmity was due to war service. So here, since there is already a statement that by the minister that the disability of the officer is already listed in the list or category entitlement for the pension, the office or the ministry was stopped from denying the right of the officer, because based on the earlier statement made by the ministry. All right. Interestingly, if you look at the second and third element, I would like to refer to the case of both-state trading, where in this case the court held that the treatment does not form part of the doctrine of Estoppel, meaning that in the case of both-state trading, the court held that you do not need to prove that you suffer losses because of the reliance on the promise made by the promisor. It's enough that you prove that there is reliance on the promise. So this principle still applicable in Malaysia, because previously, before the case of both-state trading, there were many cases, and most cases refer to the English precedents, where the court held that there must be a proof of detriment as well, because of the reliance on the promise. But from the case of both-state trading, and this case was later followed by the subsequent court decisions, that the treatment does not form part of the doctrine of Estoppel. Other cases that we can discuss, including here the case of Commissioner of the Municipality of Malacca and Senia. In this case, the plaintiff is the Commissioner of Malacca Municipality. So this municipality are the owner of premises known as quarter number 116 Jalan Bukit Cina, Melaka. The defendant, who is the plaintiff's employee, and the quarters which were allotted to him, basically he got employment because of he is employed with the municipality. The defendant joined the service on 1st of July 1938. So according to his service record, he was 25 years old at that time. He could serve the municipality up to the age of 55. If he was 25 in 1938, he must have been born in 1933, which means that he could remain in the employment up to 1968. However, the defendant claimed that he was born in 1922. Therefore, the retirement was wrongful. He was entitled to remain in the occupation he claimed that he should be entitled to remain in the occupation until he reached the age of 55. So here, what was the statement? The statement here is the statement by the defendant that the issue here is whether the defendant should retire, when the defendant should retire. So because of the statement when the defendant should retire, because in the earlier statement he informed the office, he informed the municipality that he was 25 in 1938. Therefore, he was born in 1913. But he argued later that he was born instead in 1922. So the first statement that he made, or he informed to the municipality, binds the parties. Therefore, he was stopped from denying he was 25 years old in 1938. If you can recall, in those days, they don't have the exact what we call it, surat beranak lah at that time. So there are some contention on the date of birth. So here the municipality has relied on the promise made by the defendant. Therefore, the defendant is stopped from denying that he was 25 years old in he was born in 1913 instead of 1922. Right, next we would like to proceed with promissory estoppel. This is quite familiar, I guess, with you because you have covered this in your law of contract. Promissory estoppel is an exception to the general rule in Penal Case 1602. In this case, it's an old case. A person may rely on promissory estoppel to stop a creditor from going back on his promise after he or she agreed to accept less in full discharge of the debt. And we have the provision governing promissory estoppel under our contract law, section 64, where every promisee may dispense with or remit wholly or in part the performance of the promise made to him, or may extend the time of for such performance, or may accept instead of it any satisfaction. Okay. Saya tak nampak yang kat tu sebab it's not full screen. Sekejap, saya buat full screen je. Which he thinks fit. Okay. So, promissory estoppel is based on promise made by the promisor to the promisee. So you know that there are three elements. This is almost similar to estoppel by conduct, but this is purely based on the promise, meaning that there is a verbal promise made by the promisor. So there are four elements here altogether. Number one, there must be a clear and unequivocal promise by the promisor. Number two, the promisor must show the intention that the promise is to affect the legal relationship between the parties. Number three, the promisee has acted upon promisor's promise. Number four, the promise has altered his position to his detriment by acting upon the promisor's promise. Promisor's promise. Okay. The first element, there must be a clear promise by the promisor. So here there can be express or implied promise, as long as if it is expressed, it's much easier to understand because it's very literal. From the reading of the promise, then you can have a literal understanding about the promise. But when it is implied promise, that can be derived from the conduct of the parties and from the circumstantial evidence. In the case of Hughes and Metropolitan Railways, in this case, the landlord gave the tenant 6 months to repair the property or else it would be forfeited. So within 6 months, there is a negotiation for the sale of the lease between the landlord and tenant. But the negotiation failed after 6 months and the tenant failed to repair the property. Therefore, the landlord sought to enforce forfeiture. Here, the court held that the landlord had led the tenant by his conduct to believe that the landlord would not enforce forfeiture. Therefore, the landlord would not be allowed to go back to his old promise, which is to forfeiture the land. In the case of Central London Property Trust and High Trees House, this is a landlord case where that involved a lease of flat for £2,500 per annum. That was the rental rate offered by the landlord or by the lessor. The defendant relied on subtenants to pay rent. In 1940, there was outbreak of war where the defendant failed to find a subtenant to pay the rent. Therefore, because of the failure to find a subtenant, the defendant failed to pay the rent. The plaintiff, considering the time of war had reduced the rent to £1,250 per year. And that rental rate was applicable during the time period which is between 1941 to 1945, where that was the Second World War time. So the defendant paid a lower rental rate. In the middle of 1945, the plaintiff claimed the rent at the original rate, which is £2,500. The plaintiff's claim was allowed because the court said that estoppel only arose between the or during the wartime period. So after the period has expired, the rent should be paid at full rate. So the material fact here is that is the time of war where the rent will be paid at a reduced rate. That is the material fact there. And the promise was only applicable during that period. The next element, the promisor intends to affect legal relationship between the parties. So there are a few factors to consider here. Number one, whether the promise was made voluntarily by the promisor, or whether the promise had improperly taken advantage of the promisor's difficult position, or whether there was a threat to coerce the promisor. So if you look at as a whole here, we need to go back to the unconscionability of the parties, because it is considered as a contract, so there must be a clear indication that it is free from coercion, it is made voluntarily between the parties. So if there is element of coercion or oppression, then it can become voidable, therefore the estoppel cannot be asserted to support the cause of action on the breach of contract between promisor and promisee. The third element, the promisee must have suffered the detriment. So as I have explained to you earlier, in estoppel, except for estoppel by representation, there is no need to prove detriment. But for estoppel by promissory estoppel, there must be a proof of detriment, meaning that the promisee has suffered losses or has suffered detriment based on the reliance of promise made by the promisor. So please have a look at other cases as well for the details. Okay, next is